Hello, welcome back to Last Thursday in Privacy. I'm Robert Bateman, the head of content at GRC World Forums, and thank you so much for joining us. So coming up next, well, who can keep track of the myriad changes that seem to be occurring every week in data protection law worldwide? It is very hard to keep up with the developments in this area, but we have a panel on hand to try to help you make sense of what's going on, what to expect throughout the rest of 2023 and perhaps beyond. This session is sponsored by MINE, Data Protection Regulations Worldwide 2023 overview of the current horizon. I'll hand over now to our moderator for this session, Luisa Sato.
So good morning, dear panelists, and good morning, good afternoon, good evening to our audience. I'm Luisa Sato, partner in charge of the cybersecurity and data protection area in Tosini Freire Advogados. It's a law firm in Brazil based here in São Paulo. Tosini Freire is also a member of Privacy Rules, a global alliance with integrated legal, tech, and data crisis communication expert solutions for privacy. So our challenge in this panel is to take a trip around the world in just 45 minutes so we can have an overview of the current state of global data protection regulations, highlighting key trends and developments. It is so important for us to discuss this matter among professionals from different parts of the planet. We have data protection regulations evolving rapidly around the world, just as Rob just said. Data travels easily and data breaches can have consequences in different jurisdictions. So without further ado, let's hear our panelists. I will start with Lawrence. So Lawrence, you work as the privacy manager at this big multinational that sells infrastructure, software services in information and communications technology. You certainly deal with many different issues related to data protection on your daily basis. But if you could give us an overview of the data protection regulations that are currently most affecting Ericsson's business and products, let's start with that.
Yeah, that's a very interesting beginning question. Within Ericsson, obviously, we deal a lot with different customers and different clients all over the world in various different jurisdictions. Obviously, the main one, with it being a Swedish-based company, is the GDPR, which we use as a baseline for our own privacy compliance activities. But on top of that, obviously, we have massive facilities over in the United States, and we've also got various different initiatives in other jurisdictions, such as India, Japan, and obviously, a lot going on in Africa at the moment. So aside from the GDPR, we do also have our eye on what's happening with China's PIPE law, what's happening with the upcoming Indian laws coming through, along with kind of what the updates to the African continent are going to be over the next 12 months. So there's definitely a lot to keep an eye on, and kind of a lot of things to make sure that we can make the best and most secure and privacy compliant products that we can manage.
Great. I know, Lawrence, there must be a lot of things for you to handle. Yeah, I would like to pass to Elisa now. So Elisa is the DPO of this dreamy company, Lamborghini. And well, she certainly has to also deal with lots of regulations around the world. But I know that one thing that is affecting the business right now, it's a hot topic and a big point of concern for everyone, is the international data transfers. So what are your thoughts on your regulations involving this issue and the challenges you face in practice? And also, if Lawrence wants you to contribute also with this issue, that would be lovely.
Thank you, Luisa. Good morning, everybody. Yes, as for Lawrence, the situation here in Italy is the same, because we have to manage with worldwide legislation, starting from the European one, that is the pioneer of data protection topics. So the accountability of each data controller, that it is mandatory since also the introduction of the GDPR, force all of data controller, all of the entities that would like to export personal data outside the European boundaries to comply with the rules that set forth by the GDPR. See, this is something not easy. In particular, now we are in the data-driven economy. You really don't know where your data are, thanks also to the cloud environment. So the data controller has the duty to check if it is, first of all, possible to transfer the data by following the rules set for the dedicated section of the GDPR. First of all, the scope is to grant to the data subject their rights that cannot be reduced based on the circumstance that the data controller decided that, for instance, a cloud-based in a third country is cheaper, so it's better to go there and to process data outside the Europe, with the consequence of reducing the rights of the data subject. So everything should be based on the maintenance and the keeping of the data subject rights, and it's not easy to find a balance between that and the economical reason for which a data controller would like to export data.
Yeah, I mean, absolutely. I mean, this has been a trend in privacy for the last few years now. Data transfers are something that aren't going to go away. They're going to get more complex, and in some cases, they're being weaponized by governments to kind of help broker other deals and agreements. A big one we've seen recently has been obviously the need for the US and the EU to have some kind of data transfer agreement in place. They're on the third iteration now, well, trying to get the third iteration across the line. And then obviously the other side, you've got the Global Cross-Border Privacy Rules Forum, which the US is setting up and trying to bring more countries into it beyond the Pacific Theatre. I believe the UK was one they're trying to bring in. So yeah, absolutely agreement there. It's such a big topic. And I know there have been other sessions today on this topic. So yeah, it's something that isn't going to go anywhere.
Perfect. Yeah, and Lawrence, there in Ericsson, do you also deal with artificial intelligence matters? Is there something important that we should get to know?
Yeah, again, artificial intelligence is something that I deal with. As part of my role, I'm ensuring that we have privacy trustworthy AI developed within Ericsson. I work very closely with our research and AI teams. Obviously, there is the EU attempts to get an AI Act through. Obviously, the Chinese have got some stuff with deep fakes coming through, and the US as well. But I do understand that I believe other panelists may have thoughts on this as well.
Good. So yeah, let's hear Mariano now. And well, I'd like to know about he's from Argentina, also a member of Privacy Rules. So I'd like to know the general landscape in Latin America. Of course, you can talk about international data transfers or the artificial intelligence, whatever you want that you think it's really a big topic here in Latin America. Mariano, let's hear you.
Many thanks, Luisa, and thank you for having me here. It's a pleasure to share this panel. Yeah, from a personal data protection perspective, Latin America has endorsed the EU system promoting legislation that is similar in a kind of way to the European Directive on Personal Data Protection and the GDPR. And we are seeing here the same problems that are facing the world in the sense of having an increasing amount of countries with new comprehensive personal data protection law. The list includes Argentina and Uruguay, which both joined Convention 108 and 108 Plus, and they both were declared adequate jurisdiction by the European Commission. But we have also Mexico, Peru, Colombia, Brazil with the LGPD, and there is a bill, as far to the best of my knowledge, on the artificial intelligence that is being discussed currently in Brazil. And also Panama has a personal data protection, a robust personal data protection law. Ecuador, Cuba was the last country last year in enacting a personal data protection law. And we see that those legislation are following the European Directive and the GDPR. I mean, they have a general approach that is applicable to all sectors. And we don't have a regional data protection treaty as in the case of the European Union, but we do have the Ibero-American Data Protection Network, which approved and released in year 2017 the data protection standards. This is a network. This network is an association of Spanish-speaking countries in America, plus Brazil, Spain, and Portugal, and they are represented by authorities and experts in the field. And for the coming year, we are expecting very different developments in the area of personal data protection. There are data protection bills or initiatives in Argentina, Chile, Costa Rica, Guatemala, Bolivia, Paraguay. So there are many movements on the field of personal data protection. Also, we expect the Data Protection Authority to be more alert on investigations, audits, imposing more sanctions. Maybe the sanctions that the Data Protection Authority may impose will be increased. And we also believe that there will be more civil actions from individuals and associations representing data subjects. I may stop here.
Great, Mariano. You know, we are discussing this week about the single currency between Brazil and Argentina, and this made me think about also some kind of treaty between the both countries related to data protection. We could do so much together here in Latin America, and I also expect this data protection topic to be a huge thing in our countries, especially now in Brazil, that we're going to have our first penalties imposed by the authority. So yeah, I think we are going to have a lot of work here in Latin America this year. Niall, you're the Privacy Council of BOPARC. So I know that you deal with lots of regulations, and of course you're free to contribute to what the other panelists have brought so far. But we still haven't been through the U.S. new laws. So the CPRA, CDPA, let me read those so I cannot make a mistake. California Privacy Rights Act, Virginia Consumer Data Protection Act. If you want to start with that, that would be lovely.
Yeah. Hi, guys. So, yeah, good to see you. So, yeah, I'm a privacy counsel based in Ireland. I'm an in-house lawyer. And, yeah, I suppose I'm not directly affected by the ever-changing landscape with the US laws, but I've obviously find it interesting, particularly in the context of GDPR and noticing the nuances there and the changes and how that could have a business impact on customers in the States. So one thing that struck me was the fact that the CPRA brings in the first ever US-based regulatory authority exclusively focused on privacy issues. So effectively, there's a concentrated body absolutely dedicated to enforcing the new law, which I found interesting. And I suppose the business impact from that will, I think, make businesses sit up and take stock of the fact that there's the regulator that's keeping a close eye on things, and that has to be factored into their budget. And the same for all the other differences that this important new law is brought in that didn't appear in the CCPA. So the fact, like things like correcting inaccurate personal information, it gives Californian consumers the right to demand that, say, their data is corrected or amended by controllers, so to speak, or businesses. So all of this brings in a responsibility to have a privacy team, I think, which therefore impacts on the budget. So the same with the Virginia law and in Brazil, as you mentioned there. So with things changing so quickly, it sort of depends on the culture, I think, and a culture of privacy doesn't happen overnight, as we all know, but hopefully it needs to be harnessed and sort of nurtured amongst staff as well and the regulator.
Great, Niall. You know, we handle lots of compliance projects here in Brazil, and it's sometimes very hard to get everything, for the DPO at least, to get everything running smoothly. And, we normally use platforms, and this is a big thing here in Brazil right now, because we're still developing a data protection culture. And I'd like to hear from Gal, actually. So he's from the CEO from Mine, an all-in-one privacy platform. I took a look at the product, and I think it's amazing, Gal. So congratulations on that. I'd like, if you could contribute, how do you see data mapping and maybe the adoption of other proceedings that of other practice, how could that be crucial for privacy programs to support all those new regulations that we just spoke, all the requirements?
Thank you, and I'm very excited to be here. And I'll try to inject the voice of optimism to everything that is happening, and to maybe share a little bit of light on how to navigate all of these new regulations. So, as you all discussed, there are a lot of new and upcoming privacy regulations, CPRA that is already in, Virginia, Utah, LGPD, the upcoming Indian laws, and even the ADPPA, which is like the federal US legislation, and also the increasing fines, right? Meta and Sephora and Discord. So it seems like the regulator are after new violations. And I think that all of these together really emphasize the need for a strong data mapping infrastructure. And we think that in order for companies to navigate all of these new regulations, it's crucial to really understand what we are dealing with as organizations. So it's on the one hand to really understand what we are dealing with in terms of the systems that we have within the organization, whether it's a database or any SaaS applications like our CRM or email marketing, or anywhere we keep personal data, whether it's employees or customers, and then to really have a sufficient data classification to really understand what data we are keeping in these systems. Now, and I can touch on that later on, but I think that the key for navigating all of the new environment is to really have a good data mapping that can really run fast, right? Because we want to get ROI from our privacy program and not wait months, right? Because it might be too late. And I think that this is the key to handle that new reality and making sure that we are reducing the risk across the organization, that we can really be prepared for everything that is coming.
All right. So, Elisa, are you there actually using some kind of platform there in your practice?
Yes, yes, we have introduced a platform years ago. I don't want to say the name because
it's all right.
But yes, because they are very, very useful to help the data controller to have a clear worldwide situation, because it is a matter of to be really aware where your data, the data for which you are responsible are, which are also the local legislation to whom you have some time to comply as well. So it's fundamental also to find a balance, not only in the transferring to understand, to check the level of adequacy as set forth by the GDPR, for instance, but also you have to check the local legislation, and if the local legislation provides mandatory rules that you have to comply as well, because for instance, if you have some customer based in China and you process their data locally, you have to comply also with the Chinese legislation that all of you knows that is very, very complicated to be compliant, and also it's complicated to find which of the both legislation, for instance, the European and the Chinese one, are different, which is how you can manage these kind of differences. And at the end of the day, you have always to keep in mind the business target that your company has. So it's a real matter of balance between all these fundamental topics, because first of all, as I mentioned before, we have to start by the protection and to grant the data subject rights. So it's very, very difficult. For sure, the technologies helps the DPOs to have a clear picture to have the data mapping, for instance, and to also there are a lot of tools that can help us also to have a prior overview of the local legislation, for instance, if the legislation exists, because in Europe it exists since more than 20 years, but as it was mentioned before by the other panelists, there are a lot of new legislation to be to which all of us we have to comply. So it is also a matter of knowledge and awareness as well. So
yeah, no, you're right, Lisa. It helps a great deal, and also when we had to talk to the authorities, platform always gives us good grounds for whatever we want to tell the authority and protect our client. We have questions from the audience now. We have this one here. What are the odds of the ADDPA passing in the US? So let's hear, maybe Lawrence would like to answer this one.
Yeah, I mean, as I mentioned at the start, we have a fair few dealings in the United States with the work that we do. One thing to mention about the US is that they are making massive advancements in their privacy domain. We've seen over the past 5, 6, 7 years attempts from various states to get more robust privacy legislation across the line that's more in line with, say, a European approach. Obviously, the big stumbling block in the US will always be this federal privacy law. In most regards, though, the US is seen as the EU was in 1995 with the Data Protection Directive. There are a lot of different states with different ideas, different views, and different values on privacy, trying to come together to form one cohesive action. So this isn't helped by the US political situation, where you've got the two main political parties at odds with each other. But we have seen recently, especially, more of a bipartisan approach, the need to get something across the line because they're both feeling like it's needed to keep up with the rest of the global economy. So, I mean, in my viewpoint, it may not be the exact text we've seen. It may not be even close to what we've seen, but the US is as close as it's ever been to having a federal privacy law getting passed. And, we may see it this year, we may see it next year. But it will be very high up on either the Biden administration's current agenda or, whoever the next president is. It will probably be one of the first 2 or 3 things that they will seek to pass, depending on how the election goes. So definitely very high chances, in my opinion.
Good. Niall,
Yeah, I totally agree. I wanted to say that I totally agree with him, and I think that another way to prove it is that a lot of states in the US are pushing their own local laws, and I think that we already have 5 states in the US, right, that have already passed similar regulations to GDPR or CCPA, and the prediction for this year, according to laws that are in discussions of last phases, is that there are at least a few handful of states that are going to approve similar laws, and maybe that would, once more states would get similar laws, that would even push the federal legislation to go affect widely in the US. So it would either go from the state level to the federal, or surprise us from the federal level all the way to the states level.
Yeah, I'd agree with that. I think it's probably more likely that states pass their own individual laws progressively, and as Lawrence pointed out, the political discourse sort of polarizes the sort of fast development in that sense. The IAPP US state tracker legislation is quite a useful tool. It just shows you how fast things are moving, but yeah, I'd say I'd probably agree that a federal law is still a fair bit off at the minute, simply because of the political sort of obstacles in place there.
Great. Awesome, guys. Yes, we're all worried about that, and let's see how this will develop. We also have another question from our audience, which is, will the European Commission ever review older adequacy decisions, for instance, Israel, Canada? Maybe Mariana would like to answer this one.
Yeah, sure. Thank you, Luisa. As you may know, the GDPR imposed the European Commission the duty of reviewing the adequacy decisions taken so far. According to the information we have, the different authorities in the relevant countries were requested to complete and submit certain information and submit to the European Commission, revealing that or proving that the jurisdiction complies with all the requirements and provide adequate protection to the personal data of individuals. That was the case of Argentina, as far as we know. This was submitted in 2021, and we are expecting the European Commission to render the decision. Which is very important, at least from an Argentine perspective, because there are not many jurisdictions that obtain this recognition, and of course this is quite expected from Argentina, and that was the reason why Argentina signed and approved Convention 108 and Convention 108 Plus, because as you may know, Argentina has a very old law. It was enacted in 2000 following the European directive. And the initiative of amending the data or enacting a new data protection law is quite complicated, because you have to obtain the approval in Congress, which is not easy, at least in Latin America or in Argentina. So one of the solutions was to try to approve this Convention 108 and also amend the status of the Argentine Data Protection Authority, giving more independence in a kind of way. I assume the situation is quite similar in other countries, but maybe the other other panelists can provide more information on this.
Lawrence, would you like to also weigh in this question too?
Yeah. So, I mean, from my point of view, obviously it is written into the GDPR that the EU is allowed to readdress these adequacy decisions at a predefined period or whenever they see fit. And we've seen them threaten it already with the EU UK adequacy decision, that there is obviously a sunset clause and that it will get reviewed. But we're also seeing the converse of that in terms of the Canadian agreement. Obviously, the Canadian agreement predates even Argentina's one. So it goes back a long way, and Canada's privacy law goes back even further, things from the 1980s. And there is a movement in Canada to get an updated privacy law, and the real reason is at any moment the EU can simply look at the Canadian privacy law. So this was supposed to be in the 1980s. Is this relevant anymore? And then simply destroy an adequacy decision overnight. So we're kind of seeing both sides of the spectrum here, and it all depends on what the EU wants to do. Obviously, with the UK decision, they want to kind of put the pressure on the UK to stay in line with pre-agreed GDPR terms. Whereas with Canada, they've obviously got used to that relationship already working the way it is. So yes, they will readdress things, but they will readdress it less in a fixed term manner and more when it politically suits them, I'd say is the wise term. Obviously, with everything to do with law, with everything to do with privacy, there's always that political aspect behind it. There
truly is, Clarence. Niall, any thoughts on that as well?
Yeah, again, just following on from Lawrence, similar to the American, federal law progress. I think there are always political considerations there. Obviously, with an adequacy decision, the criteria can be revisited, and the whole ethos of it is that the transfers will enjoy the similar or adequate level of protection as GDPR countries. So if, say, the whole backdrop to the US and Schrems is a lot of it is due to FISA, the home national security law, federal law in the US. So I think the Commission will always be monitoring, say, adequate countries and their own national security laws. So obviously in Israel, there's always political strife there. So if there were certain laws changed around data transfers, then then it would be wrong to think that adequacy could just be a given there. It should always be reassessed in line with our own sort of privacy standards in Europe. Otherwise, the whole protection slips and it takes away from the rights of individuals, which is the whole fundamental point, really, isn't it? So,
yeah, we have a third question here from our audience. We are seeing many new laws emerging worldwide, but the compliance requirements vary significantly. What is the best approach for implementing an international compliance program in this environment? Applying the same standards across the board? Well, that's a very hard one, maybe. Elisa, could you give any thoughts on this one?
Yes, I will get. Yes, I'm based in Europe, and for sure the European approach is very protective towards the data subject rights, but it doesn't mean that the European law could be applicable everywhere worldwide. So, for instance, when the CCPA have been implemented, there is something that is completely new compared to the European approach, because you, as a data controller, are forced to ask to the customer if they agree or not to the selling of their data. It is something completely new for the European, despite a very long story with the data protection legislation. So it's fundamental, first of all, starting from an assessment about the local law where you would like to transfer data. It's not possible to make the same approach worldwide. So each data controller has the obligation to check the local law, to check which could be the risk, which are the security measures, and so on. And another fundamental part of this activity is to provide the data subject with a privacy policy in which it is clearly set forth that the data are transferred abroad in another countries. So it is not possible to make the same approach everywhere, but for each kind of transferring has to be checked the local law and has to be applied as well. So as for the example that I did before about the California, despite you are compliant with European law, it doesn't is that exactly the same approach is correct also for a local law. For instance, in China, you are forbidden to export personal data if they are not encrypted or anonymized. So also, for instance, this kind of rule has to be applied. So it is fundamental to make a deep assessment about the local legislation, about what it is possible to do, and what you have to do in order to be compliant as well, to protect the data. So it's not possible to have a common approach. For sure, the European approach has a lot of advantages, but is not 100% compliant with other legislation also, because the approach of each country is different. Is different also the mindset of the people. So it is fundamental to go deeper to the local legislation and to understand what is necessary to be done in order to be compliant.
That's good, Elisa. Now we are facing many challenges here in Brazil because we took the GDPR as the gold standard. So even our LGPD, our General Data Protection Law, was really deeply inspired by the GDPR. But the bad thing is that, so we imported many of the concepts there, but they don't work in practice for our culture and for whatever we're facing in Brazil. So now we have this challenge of regulating those articles of the law, and the ANPD, which is the Data Protection Authority, is having lots of troubles to develop these new regulations, because in fact, our parts of our LGPD just cannot work in practice. So I totally agree with your approach. Lawrence, do you agree with Elisa's approach, or you?
Yes, I think obviously, we have to work with what we have in front of us, and yeah, the GDPR, in my opinion at least, is still the gold standard, depending on how you want to view personal data, whether you view it as an asset or as property. But one interesting movement in this recently, and I don't know how accurate our readers on this at the point of this panel, is the recent privacy by design becoming an ISO standard as well. I think going forward, this kind of standardization body will help. I mean, at least amongst industry, whereby you want to gain a competitive advantage, everybody's saying privacy compliance is the same as safety was in the early 20th century. If you are showing that you're privacy compliant, if you're showing you care about privacy, it's a great selling point. And to be able to have a measured system that's standardized like an ISO standard, I think will really move things forward. So it's ISO 31700 for those who want to do a bit of research. And it shows that you can build privacy by design into your products, tools, services, or whatever you're doing. So this is a great step forward. It isn't a legally regulated thing in terms of, there isn't going to be a lawyer coming down and telling you what to do. There isn't going to be a politician prescribing, but it's built by the industry, for the industry, and can adapt to industry needs. So it's more of it's a nice thing to have rather than it's a full-on regulation. But again, to get that kind of competitive advantage, we've seen it with Apple this year in terms of they are moving forward, trying to separate themselves on privacy. So standards, I think, are going to be a very flexible and very adaptable way forward on this. And again, that's something that's already built into the GDPR with certification schemes.
Good. We have another question here. So what will be the challenge for countries without data protection rules or laws? Mariano, I know that your country has a data protection law, but do you have an opinion on that?
Yes, thank you, Lisa. Although Argentina has an old data protection law, there are other countries in the region that have not enacted that data protection law so far. And the situation in those countries is that maybe you will not find a comprehensive personal data protection law as a GDPR-style regulation, but you will certainly find any sort of provisions addressing privacy matters. For instance, in several countries, you have the habeas data remedy in the constitution, or you have sectorial provisions addressing privacy aspects, for instance, in the financial law regulations or in the health industry. So when you are addressing a country without a comprehensive personal data protection law, that will not imply per se that this country will not have any rules addressing privacy. You will have to check whether there is any other provision in different regulations that will impact on the specific industry that should be considered for that purpose. Also, the courts may take the principles or institutions of the constitution or the civil law to address a specific case and decide on the merits based on these main principles. But it is true that we are having less countries in that situation, because, as I mentioned before, we are seeing that many jurisdictions are walking through the path of having a new regulation or initiating the proceeding of discussing data protection bills.
Good. Nayo, do you have any experience with countries that do not have data protection regulation?
Yeah, thanks, Louisa. So yeah, I do. I've worked for an Irish NGO charity, like with international presence, delivering humanitarian aid to developing countries. So a lot of those countries in Africa, for example, wouldn't have privacy laws. You know, Mariano mentions the point that, like in Far East Asia, for example, there are also a lot of developing countries like in Thailand, Singapore, that are bringing their own privacy laws into force. But in Africa, that's not the case. So certainly whenever the challenge, when thinking about challenges there from a privacy perspective, I think I took the pragmatic approach, really, because you have to be practical in the sense of there might not be an IT infrastructure in the country, for example. So even if you want to apply the standards of GDPR, it has to be from a different lens, so to speak. There might not even be any form of like computers. It might be all hard copy data, for example. So when you're applying policy, I think you need to be a lot more pragmatic and think of simple security measures, for example. So those are like security, I think, would be a main challenge in that respect. But you want to try and roll out policies that can be easily, well, not easily, but like realistically met, if that makes sense. So yeah, and that would apply for things like suppliers as well, and not getting too caught up in data processor agreements. It has to be something that's realistically going to work and that you can consistently practice, really.
All right. So we have time for just one last question here. And the question is, what is the place of the final consumer whose data is the subject of discourse globally without a viable international enforcement authority? Well, thank God I'm just the hostess here. So you have the difficult task of answering this one. Gal, do you have any thoughts on that?
Yeah, it's a difficult one. I'll try to answer that and the previous one. I think that what we're seeing from our customers today is that even though they don't have a specific privacy regulation in place in different geos, many companies understood that honoring privacy in general could really elevate the brand trust, right? And could really earn them a lot of loyalty points, trust points for their customers. So we are seeing a lot of companies that even though they don't have to deal with GDPR or even other privacy regulations, when they get a right to be forgotten request from an individual or even a data access request, if they already applied a certain privacy regulation processes in different geos, they use the same mechanism to handle other privacy requests in regions that they don't have anything. So this is also answered the previous question that it's true that it's very hard to have one workflow for all the privacy regulations, but from our experience, if you choose one privacy regulations that you think that is the most comprehensive, like the GDPR, you can decide that this is your golden rule. And instead of creating many different workflows for many different regulations, you can choose one workflow that would suit to, let's say, 85% of the cases, and deal with the remaining 15% as exceptions. So for example, Elisa mentioned earlier, they do not sell under the CCPA. So if you have anything in place to deal with privacy requests right now, whether it's data access request or data deletion, adding a do not sell process, it's not so hard. So instead of creating, again, many different workflows, we're trying to advise our customers to go with one workflow that should suit most of the cases and handle the exceptions in different ways. I hope it answers the question.
Yes, thank you, Gal. It's not actually, if you answer or not, I think it's kind of, we should have different opinions on this one. Maybe I'd like to hear someone else, even going through the polemic opinion on the existence of an international enforcement authority. Does anyone, any other panelists want to weigh in on this one?
Yeah, so I can throw my hat into the ring here. One thing that I was able to do last year was actually sit down and speak with several of the African supervisory authorities which have recently been set up. And the first question that they asked me, the first thing they wanted the answer to was, how do we handle incidents? How do we handle breaches? How do we handle issues? And obviously you then have to go and talk them through the entire incident handling process from start to finish, how best to set it up and the best way to handle it. So whilst there may not be something in place at the moment in terms of an international body, I don't think that exists for most areas. I don't think it exists for policing. There's Interpol, there's Europol, and that's probably about it. You have to rely on other governments to come in and help you. The same thing applies to privacy. I think the first thing we need to do is get on the ground some kind of supervisory authority. And based on my own personal experiences, it may be different for the other panelists, but I'm seeing that these steps are now being taken. Obviously, there's the famous Gartner quote, which is, by the end of this year, 85% of the world's population will have a comprehensive privacy law covering them. So again, if we take Gal's percentages, what do we do with that 15%? That 15% may have something in place. If they don't, then obviously we're moving forward in the right way. But steps are being taken to have this international approach to privacy, whether it's through an EU-centric body like an EDPB, or whether it's through various functions, various different trading blocks working together. But as globalization increases, we're going to see these things happening. But the first step is definitely to have the supervisory authorities in place.
Good. That's interesting data, 85%. Any other panelists wants to contribute to this one?
Yeah, I mean, globalization in privacy terms is, as Lawrence said, is inevitable. Like a lot of the new legislation that you see evolving from different places, like different continents, like I mentioned in Asia, for example, and indeed South America, have shared a lot of the same rights, the core fundamentals of the GDPR, like individual rights requests and security and just all those values that we enjoy, like the rights and freedoms and protecting the individual. But I think enforcement is another matter. Like even if you think of the different sort of discourse even within Europe in the Google Analytics case, like with the French and Belgian authorities banning that, and the sort of different views and approaches there within Europe even alone. So trying to get like a consistent position at a global scale would be challenging, but I think like anything, hopefully it'll develop over time, and it will take time, I think, obviously.
Good. Okay, so yeah, time flies when we're having fun. I certainly learned a lot from you today. So let's move to the final remarks already. I'll ask each one of you to give us a final thought, a sentence, whatever you want to close our panel. I will go in the order that is shown to me in my screen. So Lawrence, would you like to go first?
Always the worst place to take is taking the first movement here. For me, at least, 2023 is going to be just an absolutely massive year in terms of privacy. I think it's going to be bigger than 2016, 2018. We're going to see more and more nations being proactive with not only the regulations they're passing, but with the regulations they're enforcing. We're 26 days into the year, and we're already seeing massive waves being made, whether it's from the FTC in the US, whether it's from this fracas with the DPA in Ireland, Niall, or whether it's going to be kind of Meta already setting aside €2 billion ready for GDPR fines this year. We're going to see a lot of activity. We're going to see a lot of movement. And the best thing I can say to anybody working in privacy is, first of all, you've chosen a fantastic field to be involved with. And secondly, hold on to your seat. It's not slowing down this ride at all.
Good. Elisa, your turn.
Yes, for me, it's fundamental for each entity that would like to process personal data is to have a data strategy, because to properly manage personal data is not only a matter of compliance or to comply with local or abroad legislation. It's a matter of strategy that can help to reach the business target for sure, because as Gail mentioned before, also from the point of view of the customer, to trust to whom is managing your personal data is a booster, a fundamental booster to have the loyalty and the proper management of the customer relationship. So it's not only a matter that you have to do, but if your data are updated, that you comply with the quality that is also set forth by the GDPR, is something that will help your organization reach the target, increase the business, the sale, and so on. So to have a proper data strategy also from a technical point of view, because everything is moving so fast, the data-driven economy, the big data can help all of the organization in increase their revenues. But of course, all these activities are very interesting from a monetary point of view, but has to be done in the proper ways. Otherwise, the entity risk to lose money in investing in something that in the future cannot be used because they are not compliant. So it is a matter of understanding and a long-term strategy that at least 5 years, of course, is not easy to know what will happen from a legislation point of view and also from a technological point of view, but it's not only a matter of compliance, it's completely changed. And for sure, in the last year, we have seen a different approach, not only for the DPOs and for the lawyers, but also from the executives and the top management of the company. That is, for me, a very good goal.
Good. Thank you, Elisa. Gal, your turn.
Thank you. I think that in my point of view is, I think that 2023 would be the year for privacy because, again, privacy is becoming year after year at the main stage. And I think that it's also very important for many executive teams to understand that privacy should be a critical, I would say, pillar within the company efforts, and to invest the right time of efforts and manpower and money into it, because again, privacy is more than just the laws. It's a brand. It's a brand necessity. It can elevate the trust of your customers, the trust of your end users, and the executive teams of different companies should understand that it's a crucial part that everyone needs to invest in it to create a better internet future for everyone.
Perfect. Niall, you?
So who's on mute? Yes, no, really interesting points made by everyone. Yeah, I think 2023 is a really exciting time for within this privacy space. Some of the key challenges I think we've mentioned, like the rise of AI, for example, across all sectors, and how that's going to be regulated, like by things like the Data Act and the Digital Services Act to try and protect consumers. Also, like as Lawrence was mentioning about the Meta case here in Ireland, or the Meta decision, I think that shows how the digital advertising space is also going to face key challenges, and it can't just be hidden away, and T's and C's consent has to come to the fore and within the proper specific unambiguous consent of the GDPR enshrined, and then obviously the new ever-changing global privacy landscape, trying to keep up with that for international companies, I think will be really challenging. So like the entire landscape is emerging, at breakneck speed and on a truly global scale. So yeah, it's interesting and exciting times ahead for privacy professionals in 2023.
Thank you, Niall. Mariana, last but not least, you have a few seconds to say your final remarks.
Sure. Advising on a company or organization on privacy will be quite challenging in the coming years, particularly this one. We are seeing, as we highlighted during this session, that there are many countries enacting new regulations. We have those authorities supplementing or complementing the enacted law and imposing new conditions that the organization must take into account when doing business in a specific jurisdictions. We have that the data protection authorities are being more alert on enforcing the provisions of the law, plus the technology. We have the AI impact on businesses. More companies are implementing AI solutions, which could be a challenge, a big challenge from a privacy perspective. And finally, we have the data breaches and security incidents, which, according to the information I have, we are seeing an increased amount of threats on this point of view. We have no time to deal with this specific issue, but it's very important because companies must be alert on dealing when dealing with this kind of solution, when having to notify authorities within a very short time frame.
Thank you, Mariano. Thank you all panelists. This is the time we had for today. You brought so much valuable information. I thank you very much for that. So I think back to you, Rob.